Hi everyone, good evening and welcome to Thorough Newspaper Analysis. This is the video for the 31st of May 2024. Now let's proceed and have a look at the pointers of discussion for the day. So the first segment would be the editorial segment, and here we talk about an Indian Express article. This article is about the bail which was granted to Sharjeel Imam. He was charged with sedition and other provisions of the stringent UAPA. So in this article, for the purpose of your judiciary exams, what you can take home is the understanding of what is statutory bail. Secondly, we talk about what are some of the safeguards which are available to under trial prisoners. Secondly, we talk about the news updates, and this is going to be followed by the last segment where we have two legal updates to cover. So without further ado, let's start with the article and let's first understand the title. Let's first have a look at the title of it. So why Imam was granted bail and why is he still not released? So he's been granted bail, yet he's not released. So this is, sort of the heading is same that we covered in the case of Ram Rahim. But here the situation, the grounds and everything is absolutely different. So let's understand the context here first. See, despite being granted bail by the Delhi High Court, JNU scholar Imam, he will not be released from custody. He was granted bail in a case in which he was charged with sedition and unlawful activity under the stringent Unlawful Activities Prevention Act for an alleged inflammatory speech. Essentially, the charge against him is that he made a couple of speeches, a speech which was inflammatory and it had the ingredients allegedly of being a seditious matter and a dispensation of a seditious matter. So he was a JNU scholar and he was arrested in January of 2020 on the same charge that he delivered inflammatory speech, and there is other matter against him as well that we'll understand later. So arrested in Jan of 2020, he has spent nearly 4 years in prison as an under trial in this particular case. Now, please note this term. So he has already undergone 4 years of jail term while being an under trial prisoner. And the charges against him are what? So we have sedition, then we have unlawful activity under UAPA. So this is important for the understanding of why the bail was granted. Let's understand the grounds of his bail. The charges against Imam under section 13 of the UAPA, it carries a maximum sentence of 7 years. So please understand, in the UAPA, the charge which was leveled against him, it comes with a punishment term of 7 years. While sedition, it also carries a maximum sentence of life imprisonment. And in case of evolving life sentence, 10 years, it is considered as half of the life sentence for the purposes of granting statutory bail. So we'll understand what is a statutory bail, but for now, just keep this thing in mind that whenever we have to construe the quantum of life sentence or life imprisonment, then it is 10 years for the purpose of granting statutory bail. So LI is equals to 10 years for the purpose of granting statutory bail. In 2021 ruling, there was a ruling by the Supreme Court which came about in the year 2021. Here, the Supreme Court stayed the operation of Section 124A of the CRPs, of the IPC. So essentially, this section talks about and provides for the penalty, the penal sanction behind the offense of sedition. So the Supreme Court stayed the operation of this particular section of the IPC, and therefore, till the constitutional validity of this particular section and provision is determined, all the trials on sedition, including Imam's trial, they are effectively stayed. So with no prospect of speedy trial, Imam's statutory bail was the only viable option for release in this particular case, especially since his bail was rejected on merits on a couple of earlier occasions. So he applied for bail before the trial court, before the high court as well, but at both the levels of judiciary, his bail was rejected on merits. So this was the recourse which was available to him, which is statutory bail. Now, I've been saying statutory bail a couple of times. We'll understand what is statutory bail, but first, let's see this. So he has been granted bail, but he will not be released. So the reason here is that he is also in custody in another case involving 2020 Northeast Delhi riots. So because he is in custody in another matter, another case, So therefore, he will not be released. But certainly with respect to this inflammatory speech matter, as far as this is concerned, he has been granted bail. Also, please understand there are several other cases which are pending against him in at least 4 states. Those are Assam, Manipur, Arunachal, and UP, other than Delhi. He is not in custody in those particular cases, thus does not require the application of bail. So now let's understand what is statutory bail. Please mark this section. The concerned provision for this type of bail is section 436A of the CRPC. We'll understand what is this section, when was it added, and all of these aspects now. So let's first see why is it called statutory bail. See, a two-judge bench of Justices Suresh Kumar Kaith and Manoj Jain, they granted the statutory bail on 29th of May. They had little discretion in doing so because it is mandate of the statute. It is the legal mandate. So on merits, his bail was rejected several times by both the trial court and the high court. However, this time around, he was granted bail on technical ground under the statute itself, and hence it is called statutory bail. So what is the statute? What is the law in which this bail is granted? What is the provision of the law? It is section 436A of the CRPC, where an accused is granted bail if he has served half of the maximum period of imprisonment which is prescribed for the offense. So this is very important. What is the ground for granting such sort of a bail? It is that when the under trial has already served half of the maximum sentence which is prescribed for the offense for which he is behind the bars, then there is a statutory right in favor of the accused to be released on bail. Now let's see its bare language. It says, the marginal notice maximum period for which an under trial prisoner can be detained. And the provisions are as follows. Where a person has, during the period of investigation, inquiry, or trial, so at all the 3 stages, investigation, inquiry, and trial under the CRPC of an offense under any law, not being an offense for which the punishment of death has been specified as one of the punishments under the law. So if the offense is of nature which does not have death penalty as the prescribed punishment, and the person has undergone the period of imprisonment during these stages, then detention for a period extending up to 1/2 of the maximum period of imprisonment specified for that offense under that law, he shall be released by the court on his personal bond with or without sureties. I would like to read it again. When a person has, during the period of investigation, inquiry, or trial under the CRPC of an offense under any law, undergone detention for a period extending up to half of the maximum period of imprisonment which is prescribed for that offense, he shall be released by the court on his executing a personal bond, and it can be secured with sureties or without sureties as well. And the offense should not be one which is punishable with death. Now, please understand this was introduced in the statute book, which is CRPC, in the year 2005 to tackle the issue of rising population of under trials in prison. So this is a very serious issue, the crowding of the prisons, of Indian prisons by under trials. That's a very, very serious issue. This is especially helpful for under trials who are booked for offences that carry a shorter sentence. So, for example, according to the National Crime Records Bureau data for the year 2022, there were nearly 60,502 under trials across the country who were charged for offences that carry sentence of less than 2 years. Now let's understand what are the other safeguards and protections available to under trials. This safeguard is being one, you may use it in your essays as well, which is the provision for statutory sentence on the ground that you've already served half of the imprisonment, which is maximum prescribed for the offense for which you are behind the bars. The others are, let's talk about them. So first of all, for all bailable offences, it is mandatory for the court to grant bail under section 436 of the CRPC. An accused who is willing to furnish a bail bond has to be granted bail in such cases. Secondly, in cases of non-bailable offences, it is court's discretion to grant bail. At times, a lot of us get confused and we are under the impression that in non-bailable offences, bail is not granted at all. That is not the position. Please understand here, Bail is not a matter of right, but it is discretion of the court, and the discretion is judicial discretion and not arbitrary. To shield from lengthy periods of incarceration without trial, the courts also grant default bail. Default bail is under 167. Here, essentially, if let's say your investigation has not gotten over under a period of 60 or 90 days, the charge sheet is not filed, then you, by default, are eligible to bail. So, to shield the under trials from lengthy period of incarceration without trial, the courts also grant the default bail. Under section 167, subsection 2 of the CRPC, the police have 60 days to complete the investigation and file a final report before the court. For offences that prescribe death sentence or LI or a jail term of not less than 10 years, this period of investigation goes up to 90 days. So if the police are unable to finish the investigation and file a charge sheet within this period, then default bail, it is granted as a matter of right. Default bail, it is only for IPC crimes. Stringent special legislations like UAPA, they have relaxed timelines for police to investigate. So these are some of the safeguards for under trials, and with this now we proceed to the national news update for the day. RBI launches retail direct mobile application fintech depository. The Reserve Bank of India governor on Tuesday, he launched 3 major initiatives. One is Pravaha portal, second being the retail direct mobile application, and third is a fintech repository. Let's talk about these initiatives. So Pravaha, it stands for Platform for Regulatory Application, Validation and Authorization. So it is a secure and centralized web-based portal for any individual or entity to seek authorization, to seek license or regulatory approval on any reference which is made by it to the RBI. At present, 60 application forms covering different regulatory and supervisory departments of RBI have been made available on the portal. India successfully test fires Rudra air-to-surface missile. India successfully test fired a Rudra air-to-surface missile from Su-30 fighter jet of the Indian Air Force off the coast of Odisha. The Defence Minister in this regard said that the flight testing of the Rudra M2 missile met all the trial objectives. Please understand, this missile, it is indigenously developed solid propelled air-launched missile system which is meant for air-to-surface role to neutralize several types of enemy assets. The government cracks down on SMS scammers, blacklist principal entities found spewing fraud messages. In a major crackdown on SMS scammers, the government has blacklisted principal entities behind SMS headers that were used for sending over 10,000 fraudulent messages over the past 3 months. The Department of Telecommunication, in collaboration with the Ministry of Home Affairs, has taken decisive action to protect citizens from potential SMS fraud through the Sanchar Sathi initiative. This is an important initiative of the government, given the fact that in today's day and age where technology has just become an integral part of our lives, we know how frauds at such massive levels are affecting lives of people like you and I. The Indian Cybercrime Coordination Center under the Ministry of Home Affairs provided information about the misuse of 8 SMS headers for sending fraudulent communication for committing cyber crimes. The Central Council for Research in Ayurvedic Sciences has launched the Pharma Research in Ayurgyan and Techno Initiative, which is called Pragati. The initiative is called Pragati 2024. I would like to read out its full form again. So Pragati, it stands for Pharma Research in Ayurgyan and Techno Innovation. It is an initiative to promote research and innovation in the field of Ayurveda. This initiative aims to provide an opportunity for collaborative research between the Central Council for Research in Ayurvedic Sciences and the Ayurveda drug industry. Next up is an update in the category of important days, and the day concerned is Goa Statehood Day. Every year, Goa Statehood Day, it is observed on 30th of May. Goa used to be a Portugal colony for more than 450 years. It was back in 1961 when Goa was freed by India, and it was given the status of a union territory alongside Daman and Diu in the year 1986. So independence was secured in the year 1961. The status of a union territory was given in the year of 1986, and then later in the 1987, I'm sorry. And later in 1987, the same year, Goa was given the status of a state. It turned into the 25th state of the Union, Indian Union that year. Panji was announced the capital of the state, and Konkani was declared to be the official language of Goa. From that point onwards, Goa Statehood Day is observed every year on 30th of May. Now here I have a couple of questions, and I would encourage all of you to answer the same in the comment section. First is, by virtue of which amendment Sikkim became a state in India and it was inculcated in the Indian Union? Secondly, which is the first state that was formed in our country on linguistic basis? And also, which schedule of the Indian Constitution deals with the languages, and how many currently languages are there in that particular schedule, and what was the latest amendment that was done in that particular schedule, and by virtue of that amendment? Okay, so I'll give you the amendment. I believe it is 92nd amendment. So by virtue of 92nd amendment, which languages were added in that particular schedule? Let's see how many of you are able to answer these questions. So this has brought us to the international news segment, and here we have an update from New Zealand. New Zealand tightens visa regulations, shorten work permits for international workers. New Zealand tightens its visa regulations, citing high unsustainable net migration levels and introducing additional criteria like skills and language requirements, as well as shortening the length of work permits which is issued to international citizens. And all of this is due to the high influx of migrants. So let's understand what is the reason of tightening the visa regulations. So please understand, nearly 173,000 non-New Zealanders, they migrated to the country last year alone. So with a population of 5.3 million, New Zealand has been seeing a surge in migration since 2022. Through these rules, New Zealand government is planning to develop a smarter immigration system, which would eventually lead to managing the net migration. And there was also a concern about the competition for work opportunities if the influx of migration continues. So what have been the major changes in visa regulations? Let's understand that. The authorities introduced English language as a requirement for migrants who will be applying for low-skilled jobs. So in order for you to apply for low-skilled job roles as well, you need to have understanding and fluency in English as a medium of language. Secondly, in most work visas, applicants will be required to show work experience and would be required to possess certain skills. Before offering a job, employers will have to ensure that candidates possess these skills. In most work visas, applicants will be required to show the skills and would be required to possess certain skills. This we've already covered. Now, this has brought us to the legal update segment, and first update is from the High Court of Madhya Pradesh. Hindu-Muslim marriage invalid under Muslim personal law. Madhya Pradesh High Court refuses protection plea of interfaith couple. So essentially here, let's understand the facts of this case first. The petitioners, they stated that they are a couple and they approached the marriage officer under the Special Marriage Act. However, on account of objections which were raised by the family of these, the family of the couple concerned, they could not appear before the marriage officer, and as a result, their marriage is not being registered. And fearing, injury to their life, liberty, and limbs, they were before the High Court of Madhya Pradesh seeking protection. So the Madhya Pradesh High Court here refused to grant protection to this interfaith couple, observing that a marriage between a Muslim man and a Hindu woman, it was invalid as per the Muslim personal law. Usually, this is the recourse that suppose if there's a couple and there is a threat which is posed to the safety of the couple by their, let's say, relatives or family members, then they usually approach the High Court with a protection plea, seeking, let's say, directions to the police to grant them protection. And usually the High Courts do grant the, do give directions to the concerned law enforcement agencies, saying that kindly provide protection to the couple concerned, and if there is any, let's say, criminal intimidation or any physical violence which is committed against the accused, then take the recourse to criminal law, IPC and CRPC, and lodge FIR against the concerned family members, so on and so forth. So this is the recourse of the court. Now here the High Court refused to grant the protection plea, and while observing that a marriage between a Muslim man and a Hindu woman, it was invalid as per the Muslim personal law. In this background, so the facts of the case we've already seen. And here the couple, they sought, among other reliefs, protection to appear before the marriage officer on the date which is fixed for the registration of their marriage under the Special Marriage Act. The court refused protection, stating that the marriage between Hindu woman and a Muslim man would be irregular as per the Muslim personal law. The court here said, and I would like to quote it out, as per Mohammedan law, the marriage of a Muslim boy with a girl who is an idolatrous or a fire worshipper, it is not a valid marriage. Even if the marriage it is registered under the Special Marriage Act, the marriage would be no more a valid marriage, and it would be an irregular marriage. Secondly, we have an update from the Honorable High Court of Karnataka. So the Karnataka High Court has held that the provisions of the right to children to free and Compulsory Education Act of 2009, they're applicable even to residential schools. A single judge bench of the Honorable High Court dismissed the petition, which was filed by the Janna Sarovar Educational Trust, which runs a residential school without any granted aid, offering the Indian School Certificate Examination syllabus. And they challenged an order which is dated 23rd of November 2021, by which the authorities imposed a certain penalty for non-compliance with the provisions of registration under the Act. So that's about this particular verdict, and the name of this case is Janna Sarovar Educational Trust versus the state of Karnataka and others. So essentially, the court said that these residential schools, they are also covered under the ambit of the 2009 Act. So this has brought us to an end of our DNA. Thank you so much for watching. Have a wonderful day.